Matthew Mortoma insider trading case.
Yes, the most famous insider trading case there is. Yeah.
The Investor Choice Advocates Network presents SEC Roundup.
Hey everybody, welcome back to SEC Roundup. I'm Nick Morgan, the co-founder of Investor Choice Advocates Network and the co-host of today's episode of SEC Roundup, joined as always by my co-host, Tom Zucchero. Tom, good morning.
Good morning, Nick.
And today we have as a special guest, Erin Smith. Erin is an executive vice president at Compass Lexicon and was previously an assistant director in the SEC's Division of Economic and Risk Analysis, or DERA. Erin, thanks for joining.
Thank you for having me.
So the reason we're getting together is what has now become a frequent topic for SEC Roundup, and that is the recurring issue of disgorgement, which is incredibly important in SEC enforcement matters, whether you're a defendant or whether you're at the SEC. And specifically, the Supreme Court earlier this month rendered its opinion in a case called SEC versus Sripetch. We think we're pronouncing his name right, so Mr. Sripetch, tell us if we're wrong. But the case seemingly, Tom, was pretty straightforward. It was the question presented was whether the SEC could obtain disgorgement in the absence of proving investor harm or financial or pecuniary harm. Unanimous decision in the SEC's favor. The answer was yes. So that doesn't seem like there's much to talk about. But Erin wrote a very insightful article that captured our sort of reaction to the opinion, and the title of your article, Erin, was "Sripetch May Prove to Be an Empty Victory for the SEC." We'll get to why you wrote the article and what your point was there. But Tom, just give us a little context first before we go there. Remind us, go to basics. Remind us, what is disgorgement? Why is it important? And what did the Supreme Court do in Sripetch? And then we'll get to Erin's points on the case.
Yeah, thank you, Nick. So disgorgement is one of the SEC's equitable remedies, and it allows the SEC to require the wrongdoer to pay back any illegal profits that it earned from the conduct. The key word in all of that in the sentences is it's an equitable remedy, and that was challenged before the Supreme Court, which resulted in a case called SEC versus Liu, which dealt with whether or not disgorgement was an equitable remedy. That was a 2020 case, and the court says, yes, it's an equitable remedy so long as a disgorgement award complies with typical equitable principles. And two of the principles they articulated that disgorgement must comply with is, first, it must not exceed the wrongdoer's profits, and the money must be awarded to victims for the benefit of victims. So at the time, Justice Thomas said, we really aren't giving enough guidance to the courts, which was 100% accurate. The courts struggled with the question, and the circuits were split as to whether disgorgement is an appropriate equitable remedy when investors have not been harmed. Wrongdoer made profits, but there was no investor harm. And the circuits were split, and that was a direct question that was answered by the Supreme Court in its Sripetch decision. And the court said, no, the equitable remedy of disgorgement could include requiring a wrongdoer to give up his ill-gotten gains, and that is separate from investor harm. So the court said, look, you don't need to show investor harm. But unfortunately, and as Erin pointed out in her article, there are so many questions that weren't answered. And some of them were noted by the justices during the argument. Like, what do you do with a jury trial right? Even if there's ill-gotten gain but no investor harm, can the SEC still get disgorgement without a jury trial? And then the question that Erin looked at is, well, it didn't address what happens in those cases where the money isn't awarded to victims. And the SEC doesn't publish data on how much or how often it's able to award disgorgement to victims. But Nick and I, you and I used to do this, and we know that sometimes you can identify the victims and sometimes you can't. So The open question is what happens in those cases where you can't identify victims, even though there was victim harm, you can't identify the victims. And with that, I'm going to turn it over to Erin to describe her perspective on that question.
Yep. Thanks, Tom. And Erin, before we get to yours, let me just, because we're going to focus on this returning money to victims issue. ICANN, of course, submitted 2 amicus briefs in the Sripetch Supreme Court matter. Justice Thomas cited one of our briefs explicitly in connection with the jury right issue. We'll set that aside and litigate that in future cases. And then another issue that the Supreme Court, I mean, this opinion was full of things where the court was saying, we're not deciding this, and we're not deciding that, and we're not deciding this other thing. Sripetch's fact pattern, of course, involved a fraudulent manipulation scheme, and he had a criminal case that was in parallel to the SEC civil case. So it seemed like the court didn't have too much of a hard time getting to allowing the SEC to pursue disgorgement. One of our briefs pointed out that it's not just in the fraud context that this disgorgement issue comes up. And in fact, it's in the non-fraud cases where you get really lopsided awards of enormous disgorgement and pretty small, puny penalties. So one of our briefs pointed out that, of course, the SEC has more than one tool. It's not limited to disgorgement. It also can pursue civil penalties. And so the court didn't get into those cases where a punishment through a civil penalty might be more appropriate than disgorgement. We've got a client right now, we're litigating a case where she's a relief defendant. So she's not accused of violating any law at all. And they want her to write a big disgorgement check. So, but that's another issue the court didn't decide. So let's get to this issue of the SEC identifies some ill-gotten gains. So in Mr. Sripetch's case, he engaged in market manipulation and profited. So there's a specific dollar amount there. What was the specific issue you were getting at that kind of arises in the context of this inability to identify victims? How does that connect with the return of the money and what to do with the money from disgorgement?
Yeah. So, I mean, in this case, for example, so it's kind of a pump and dump scheme pattern. So the defendant here called some promoters, tried to get people interested in the stock, and then sold his shares. And I guess the question is, why wouldn't the SEC be able to make a showing of pecuniary harm under that fact pattern? And if it can at the same time come up with a disgorgement distribution plan that actually is going to compensate investors. So to me, the question that the court didn't decide, what do you do if you can't come up with a distribution plan that's compensable, is basically the exact same question. I'm not sure there's really any daylight between that and what do you do when you can't identify a harmed investor, an investor who suffered a pecuniary loss.
Yeah.
So that's the gist of the
Yeah.
thesis, and happy to talk through the specifics a bit more if it'd be helpful.
Yeah, maybe you can give us an example from another context that's not a pump and dump. But before you do that, so one of the cases that the Supreme Court was resolving a split among was the Second Circuit, a case called Govil.
Right.
And in Govil, that also involves some kind of a open market manipulation. And so the Second Circuit told the SEC, you must prove pecuniary harm before you can get disgorgement. And interestingly, the matter gets remanded back down to the district court, and the SEC did just that. Like, they hired an economist. The economist performed what private securities litigators do all the time, an event study showing how the disclosures impacted share prices. I haven't looked to see about distribution, but private securities litigators don't have a problem distributing money that they obtain. They get a distribution agent. They identify who the shareholders were at the period of time in question, and then they distribute it. So, but maybe that's not something the SEC can or would do. Maybe you can give us an example from another. Well, go ahead.
Well, no, I think the SEC does do that. I mean, certainly after Lou, in my experience, there was a real concerted effort to try to give the money to investors when it could identify harmed investors. I think that's fair. It's just there's a lot of contexts where it's not straightforward. And those contexts line up pretty closely with ones where the SEC would also have a hard time making a showing of pecuniary harm.
So maybe one example to help us think through this problem with identifying and recompensing harmed counterparties would be the insider trading example, which is, presents fascinating possibilities. Can you talk a little bit about how this identification of a victim is difficult in the insider trading context?
Yeah. So historically, the SEC has usually thought about the harmed party in insider trading cases as being the counterparty to the insider, right? So an insider has some good information, buys the stock without disclosing that information, and whoever sold the shares to that counterparty or to that insider, they didn't have the benefit of that information, so maybe they were harmed. The challenge there is that there's a bunch of other people who sold the shares under the exact same circumstances.
Right.
And those counterparties, the ones that were the counterparties to the insider, they probably would have sold either way, whether the insider was there or not. And so it that approach really does create the appearance of a windfall, right? Because there's just some seller who lucked into being opposite the insider, and then they're going to be compensated. So that seems like wouldn't truly compensate investors in a way that's consistent with the real harm that's created by insider trading.
Right. Right. And of course, you've got the identification problem. Who is the specific counterparty?
Who exactly is that
Yeah,
counterpart?
yeah,
Right.
yeah. Yeah, while we're on the insider trading topic, I'll point out one thing. You mentioned that a theoretical harmed party is the issuer. The misappropriation theory of insider trading suggests that it's a misappropriation of information from the company.
Right.
But we have a recent example where the SEC actually opposed the issuer from getting the proceeds. It was the Matthew Martoma insider trading case.
Yes. The most famous insider trading case there is. Yeah. So and it's an interesting case. So the Matthew Martoma had information about a company called Wyatt, which doesn't exist anymore. And I can't remember which direction. Sold the stock, I think. And then Pfizer purchased Wyatt, but the SEC got a huge award, like the biggest award in history. Distributed money to investors, had some money left over, and the SEC was about to return that money to the Treasury. And Pfizer, who purchased Wyatt, I don't know, sometime in between,
Yeah.
opposed the return of the money and said, no, we're harmed too. We're the corporate issuer here whose information was expropriated, and you should compensate us. So a very interesting case.
Yeah. And the SEC opposed that, and the court agreed with the SEC. And so Wyeth/Pfizer didn't get any of the money, which to me just like undermines the whole idea of a misappropriation theory, that the information is being misappropriated. Who was it misappropriated from?
Although I think there's been some development there where the SEC then agreed to that maybe Pfizer would be entitled to some portion.
Gotcha. Okay. Well, that would be just.
Which is the only example I can come up with.
Right,
Not like
right.
that. So
But back to your example of where the possible victim of the wrongdoing is the counterparty to the trade.
Right.
There are real problems and challenges in identifying the harm and identifying the victim. And so where does that leave us with Sripetch? Does that mean that's an issue that's going to be fought over in insider trading cases?
Well, yeah, so I basically think Sripetch doesn't offer much guidance to the commission or defendants really at all because, again, there's just no daylight between being able to come up with a distribution plan that's feasible, that makes sense, that's going to compensate victims
Yeah.
for their losses,
Right.
unless you could actually show losses.
Right. Right.
So,
I think shortly after Lou came out, it seemed to us from the defense perspective, and maybe you were still there at the time, that the SEC for a brief moment stopped seeking disgorgement in insider trading cases specifically because the penalty scheme there really probably, in my view, addresses the question where you can get treble the amount of profits or of losses avoided. So the
Right.
person gets punished. There's no question they're not going to keep the proceeds. It's just called a penalty rather than disgorgement. Maybe that's where this ends up for insider trading, is the SEC just pursues penalties and doesn't pursue disgorgement.
yeah, but I mean, perhaps I have more insight into the kind of internal thinking from the post Lou than I do, I've no special insight now, but
Right.
I think the SEC probably is going to, if I had to guess, I think they'll still move ahead as they would have before this case with just a little bit less anxiety where there's not a very clear-cut harmed party.
Right.
And then I expect the question to come up again very soon about what's going to happen when you can't come up with a good feasible distribution plan. And you're right, the SEC doesn't publish any statistics to help with this. I tried to research it a bit for my article. I found a very old GAO report about collections in the SEC, and it's just very hard to get real numbers here. I mean, I think, it- you know, the SEC's advocate said 88% of the money that is collected is designated for a distribution, but we know that a lot of the money designated doesn't get distributed to investors.
Yeah.
And on the other end, I had some statistics in my article that the SEC got orders for 25 billion and distributed 3 billion of that. And those are numbers from the last 5 years. And so, pretty wide range there.
Yeah. That was actually the figure that Justice Thomas cited our brief for, was on the difference between awards and distributions.
Okay, yes.
An interesting number that is reported in the SEC's annual reports is, and maybe you have some insight into this, there is an account at Treasury called held for distribution. So
Okay.
these are amounts that are actually collected. So they're awarded, they're collected, and it includes penalties and disgorgement. Post Lou in 2020, the number went from non-existent to like a couple billion. And then every year it's gotten bigger and bigger and bigger, so that this last annual report for fiscal year 2025, the number was like $5.2 billion of collected, and the name of the account at Treasury is held for distribution, so not distributed.
I see.
It
Okay,
looks
so it's
like
just
there is
sitting around.
massive bottleneck of collected but not distributed. And I think this goes down to the point you made in your article, which is it's really hard to identify where to send this money. So it sits at Treasury, and I imagine, maybe it ends up being a windfall for the government.
Yeah. And I mean, I think, just coming back to the insider trading context, you could think that there's just a general market integrity loss, right, from insider trading. Households don't feel comfortable investing in the stock market, maybe because they worry that they're not the insider that has a special edge.
Yeah.
And so, that harms everybody, right? That harms households, whether they invest or not. And so I think that might be the intuition that the SEC is hoping to appeal to in a future case.
Yeah. Yeah. No, I think you're right. The question is whether it's a penalty or disgorgement. Tom, I cut you off.
That future case is going to come soon. I mean, someone's going to challenge a disgorgement award when the victims are not easily identifiable.
Yeah. Well, so just to reiterate what we put in our brief, we have this relief defendant. The SEC said that they had identified specific victims. So relief defendant, not accused of violating any law. The perpetrators of the violations were sued, had disgorgement awards and penalties against them in massive amounts, including the amount that went to the relief defendant. The SEC continued pursuing the relief defendant, who had no awareness of the underlying conduct. We're in the First Circuit. I think this is a perfect example of, the SEC said they had identified victims. The judge awarded disgorgement and said, but before I award prejudgment interest, SEC, identify these victims. The SEC couldn't identify any victims. And so the court declined to award prejudgment interest, but held the award of disgorgement. So that's a perfect example of an award of disgorgement where there are no identified victims. There is no violation of any law whatsoever. And this poor client of ours is being asked to write a check basically to the U.S. Treasury, which serves no purpose other than to punish her for something she didn't do. So will it be litigated? Absolutely, because we're going to litigate it.
Yeah.
We don't, somebody else will. So anyway, well, I think this is fascinating. And Erin, I hope you get retained as an expert to help parse out, whether and where there are victims in the next disgorgement case. In the meantime, we'll maybe tune back in a few months and see what happens as the Sripetch Supreme Court opinion gets applied in the district and appellate courts. So thank you so much for coming on, Erin. Thanks as always, Tom, for co-hosting. And for everybody else, please join us on the next SEC Roundup, or more information at icanlaw.org.
Thank you.